By this going away, the non-solicit doesn't go away, right? So I can make somebody sign a non-solicit. You won't go after my employees or my customers, right?
So let's talk about that.
This is the PMP Industry Insider Podcast.
Hello, everyone. Welcome out to another episode of the PMP Industry Insider Podcast, where we take a look at what is changing in the pest and lawn industries, and we take you to the front lines to those that are driving those changes. As always, I'm Donnie Shelton, owner of Triangle Home Services, which has Triangle Pest as well as Triangle Lawn. And with me is the Florida, by the way, I got very, very reprimanded for calling this person a northerner resident, but our newly Florida man, he does like that name, Mr. Dan Gordon. Dan, would you like to say good afternoon, introduce yourself, our sponsors, our gracious sponsors?
Yes, here I am recording from New Jersey. I am back from being the Florida man, but still a Florida resident. But Dan Gordon, PCL Bookkeepers and M&A specialists, accounting for the pest control industry, as well as exit planning services. And if you like what you hear, please support our sponsors. If you're interested in marketing, it's Coalmarch by WorkWave. To learn more about that, it would be coalmarch.com. And if you want insurance for the pest industry, auto liability, GL, EPLI, and others, it's PestSure. Visit them at pestsure.com. And if you're interested in joining a PMP Industry Insider peer group, please visit pmpindustryinsider.com/peer groups, or go back and listen to episode 136 for more information. Donnie, I don't know if you know this, but we're having a peer group meeting with David Billingsley in Napa. So everybody's going to be going to wineries and things. So
let me sign up.
Didn't take long
for a wine connoisseur.
It didn't take long for the vacation club.
Well, I would go just to make fun of you when you drink wine.
Yes, you can.
Yes, I would definitely go for that.
Yeah. So. Oh, okay. That's cool. Anyway, today, very, very excited. We are talking about the 3 new regulations employers need to know about. And we're welcoming back Jean Seawright from Seawright Associates, one of our favorite repeat guests, favorite. And so that this way it doesn't look like I read that, but okay. Anyway, Jean is president of Seawright and Associates, a human resource consulting firm that specializes in providing advice and solutions to clients nationwide to reduce legal liabilities, enhance profit and productivity, improve morale, and ensure compliance with state and federal employment regulations. By the way, Jean, if you want to come and join us, we need all of that. Jean is a frequent speaker at state and national trade associations, a columnist and an author of numerous articles and publications in the field of human resources, and she serves as an expert witness in lawsuits involving HR matters. Welcome, Jean.
Thank you, Dan.
Hey, I need to add something before we get going here. By the way, and we didn't coordinate this beforehand, but I'm going to do it anyway. For those that are listening, I actually use Jean's services. She's been fantastic. And so if you have anything HR related, or just kind of weirdness, she's a great person to talk to.
Or before it gets weird.
Ideally on the front side of that. But I will say, we have very much enjoyed having Jean as our partner. She's done a great job for our company. And she's obviously not compensating us for any of this, but I would just say, for those that are listening, if you're not associated with Jean, you might want to, especially as you get bigger and issues get weirder and crazier and harder. And so it's good to have a sounding board. So I will say, certainly thank you, Jean, for giving us a hand here at Triangle. And thanks for being on the podcast.
Oh, thank you. I appreciate that. Both of those. Yeah. Happy to be here.
Yeah. So we have a lot to talk about today. It seems like every time there's a change in regimes, if that's the right word, we get a new set of employment laws, and we're coming up for an election. So let's see what happens there if we change again. But today we're going to talk about the independent contractor rule, which that's a biggie. The exempt employees are also AKA the overtime rule, and then non-competes, and that's a biggie. So
the lack thereof.
Yep. Or the lack thereof. So anyway, Donnie, do you want to dig in, or do you want?
Yeah, let's start with this contractor rule. Let's get going with that. So can you just kind of walk us through, Jean? Like, first of all, let's talk about kind of the background and then what has changed. I think that's probably a good place to start.
Okay, so this is the U.S. Department of Labor final rule on independent contractors. It was issued earlier this year and it took effect in March. So it is already in effect, but this is the rule that pertains to the classification of a worker as either an employee or a contractor under the Fair Labor Standards Act. So the Fair Labor Standards Act is the federal law that deals with, governs minimum wage and overtime. And so we're talking exclusively and specifically about independent contractors under that federal law. And essentially what's happened is the Department of Labor has changed course, and they are now using a 6-factor test to determine whether or not an employment relationship exists. The new 6 factors, it's actually kind of a totality of the circumstances approach. So no one factor carries any more weight than another. It will depend on the circumstances as to, what weight they give each of those factors. So it's a little more complex to make this decision now and to determine whether or not somebody does qualify as a contractor. I'm happy to mention the 6 tests. There's a lot to them.
Yeah,
but I think I rattle them off. It might be helpful to the listeners. So the first one is the opportunity for profit or loss, depending on managerial skill. So it goes beyond just opportunity for profit and loss. It's really focused on the level of skill that the worker has in determining their own economic success in performing the work. So can they negotiate charges themselves? Can they accept or decline jobs from the employer, or can they dictate the order in which those jobs are done? Can they make decisions to hire others? So those things would affect their ability to make a profit or a loss on that job. So they're going to look at that factor. The second is the investment by the worker and the potential employer. They'll look at both. The financial investment, if you will, and whether or not they're capital or entrepreneurial in nature. So this is beyond like a tool that an employee might have to buy. They consider that to be more of an example of an employee when you have to purchase a tool or a uniform. This is about costs and expenses that serve a business-like function, like marketing costs, okay, investing in advertising, that kind of thing. So they want to see what investments has the worker made to advance their entrepreneurial efforts. The third is the degree of permanence of the work relationship. So this one has been around for a while. We're used to this one. And it has to do with how long the relationship lasts. So with a contractor, we know that they're usually in and out. They do a job and they're done. But with an employee, it's indefinite. Now, there's obviously employment at will. You can fire an employee. You can fire a contractor too. But they look at how long that relationship it is and how long it goes on for. The fourth is the nature and degree of control over the performance of the work and the economic aspects of the working relationship. So this goes to, again, who's in control of the work that's being done. And on this factor, I'll just give you a couple examples because some of these are really kind of hard to understand, but they're looking at whether the potential employer sets the worker's schedule and supervises the actual performance of the work, or if they explicitly limit the worker's ability to work for other people, which would be a non-compete type thing, whether the potential employer uses technology to supervise the performance of the work. So is there some kind of an electronic device that they're recording their work or documenting their work on? And whether the potential employer controls the economic aspects of the relationship, including control over prices or rates for services, and the marketing of the services or the products that are provided by the worker. So they're looking, again, economic aspects of the relationship. The fifth factor is the extent to which the work performed is an integral part of the business. This one is almost real obvious to know and to see. An example of this in the pest control industry would be, if you're a PCO and you you don't offer bird services. So you hire a contractor to do that. That's clearly not an integral part of your business, but you have a customer who may have that need. And so you'll hire a contractor. If, though, you are a business owner that has that service, you normally offer it, you advertise it, you hire techs to perform that service. And now you bring someone in and say they're a contractor doing the same exact thing, that would be a problem. So that's
So how about within the so something like you're a bird, you do bird work, and then I don't know, you have to get a crane or a scissor lift and somebody to operate that scissor lift or something. You don't usually do that. You don't have to hire them as a W-2, would you?
no, that's a good example of when you wouldn't have to.
Okay.
Then the sixth one is the skill and initiative used by the worker in connection with a business-like initiative. So they're not looking at necessarily just the skill that the person has. They want to know, how does it contribute to them advancing their business? Okay. These new, I guess, these new factors, although some of them are familiar because they existed in the past, they're being defined differently. And they're parsing the words, and they're really going much deeper into this analysis. So it's not as simple as it used to be. And then there's we'll call sort of a seventh factor, although it's not formalized, but the Department of Labor made it clear that they'll look at other factors that they would determine on a case-by-case basis. And so it's kind of a wide open option for them to just consider other factors. So that also makes it very ambiguous and difficult for employers to know what that might be in a given situation.
So this is kind of an obvious question, but why would a business owner want to classify somebody as a contractor versus a W-2 employee?
Well, there's a lot of savings associated with it. Frankly,
Right.
It oftentimes does come down to money. We know from studies and from experience that employers can save up to 40% on labor costs. And it isn't just that they don't pay the taxes, the payroll taxes, but they're not providing benefits. In most cases, the employees aren't eligible, the independent contractors aren't eligible for workers' comp, health insurance, state mandated leaves of absence, fringe benefits like PTO or sick leave. Independent contractors can't start a union or join a union. They're not protected under discrimination or anti-discrimination regulations. So it's easier to hire and retain a contractor in terms of, you don't have to follow all these rules. At least that's what the employer thinks. But that's the trap. That's the trap, because simply labeling someone as a contractor and requiring them to complete a 1099 does not confer that status.
Right.
That's what the Department of Labor's point is. And they also made it clear, we don't care if it's common in the industry. Contractors are extremely common in construction. We call them subcontractors, right? And they're basically saying, we don't really care that that's a common thing in a certain industry, because in order to qualify, they have to meet certain tests. So yeah, big change.
So question I have, you said earlier that it makes it very difficult for employers to comply, but it would also seem like it would be very difficult for the Department of Labor to enforce as well. Like there's so many, like to me, and by the way, I'm not asking for this, and hopefully no one from the Department of Labor is listening. We don't hire independent contractors anyway, but having said all of that, like if I got a claim and said, well, these people are out, I mean, is there some sort of appeal process? And like, I mean, to me, it's like the more complex you make it, the more difficult it becomes to say, this is on this side of the line versus this is on that side of the line. Is that also the case as well? Like it's I guess there's really two questions. Number one, is it very difficult to enforce? It seems like it would be. And then second, is there some sort of appeal process if for whatever reason you've been found that no, you're classifying these folks wrong and now you have to classify them as a W-2 or whatever?
So remember, there's other federal laws that come into play that have their own tests for what a contractor is. So the IRS is, probably the most famous one people think about. Their tests are different. So the tests are different under each of the federal statutes, and they're also different under state regulations. So it's difficult, first of all, to determine whether or not a worker is a contractor under all those. You could be a contractor under one, but not another. But in terms of the Department of Labor, what can happen, and I'll tell you how it usually happens. This is kind of funny, interesting. I guess you would say it's not funny, but a worker who's classified as a contractor who loses a job will file for unemployment. And they'll be told, well, no, your employer or the employer reported that you're a contractor, so you're not eligible. Well, wait a minute. But I worked there for a couple of years and I was paid a regular salary. And so it kind of comes in through the unemployment door. Unemployment is a tax, right? So now there's all these sharing arrangements between these federal agencies. So now unemployment can tell the Department of Labor, let's say, or the IRS. And so you're going to be dealing with this at multiple agencies. The Department of Labor's concern is minimum wage, overtime, record keeping, what is work time. So when there is a question there or a complaint and there's an investigation, they can interpret this and enforce it any way they want. They have an amazing amount of authority, okay, to enforce their regulations. So if they determine that you have a worker who's misclassified, then they're going to want to make sure that you again complied with the rules, and there will be back pay. So if you didn't pay overtime, for example, that's the most common problem, then they're going to create an amount of overtime that they believe the person worked based on interviews with them. If you don't have records, which you wouldn't because they're a contractor, so why would you make them keep a time record, right? So it's going to be back pay, and back 2 years, 3 years if they believe it's willful. Is there an appeal process? Not really. You can say, I'm not going to pay, sue me. And guess what they'll do? Sue you. So, but at that point, you're so deep in, think about it. If it comes in through the unemployment door, you got that going. They're saying, hey, wait a minute, you didn't pay unemployment taxes on this person. This wasn't in your payroll reports. Right. And then it goes to the tax, and Dan, you know a lot more about this than I do, but there is a program that the IRS has where you can get some, I don't call it forgiveness, but some consideration if you've misclassified a worker in terms of savings on back taxes.
Right. But it's also on the contractor, right? So you're as an employer, I'm skipping out on the payroll taxes, but that guy should have paid the taxes on his 1040.
He should have.
And
his
sometimes
federal, yes, he should have.
Happen that way. So.
Yes. Yeah. So there's just all sorts of difficult things an employer will deal with if there's a complaint or an investigation. And as I said, it comes innocently, in a sense, through the unemployment door, usually. So
you kind of touched on this, but so there's a change. It's way more complicated. It's way more, I guess, specific, a little bit more, how does this impact PMPs? I mean, there's obviously, we do use, I would say independent contractors in our industry, and I'm sure most are aware of that. But can you just talk through, what's the impact for folks that may be listening? What are some things that they need to be thinking about and things they need to be looking at and concerned about as a result of this change?
Well, if they don't use contractors, then nothing to worry about, right? Because there are businesses that really don't do that. But if they do, it really is time to stop and reevaluate those relationships. And if they're kind of noted in their records as a subcontractor or a contractor paid with a 1099, then they need to really evaluate the entire relationship and start looking at whether or not the worker has a business, is in business for themselves, is working for other employers. Is this an integral part of the services that you offer? You're going to have to begin to kind of walk through all of those factors and assess whether or not you believe there is an employment relationship. And if there is, then it's a matter of changing the status, which in and of itself could have some risk and liability, because the worker may say, well, wait a minute, first of all, I don't want to be an employee. I want to be a contractor. And secondly, well, if I am an employee, then, I was working 50 hours a week for the last couple of years for you. Right. And, where's my overtime? So, but what's the greater risk? Keeping them like that or making it
till somebody gets hurt and there's no workers' comp. But what is the likelihood that it stays in effect as if we get a change in party, and we go in that direction? have they already said that we're going to roll this back, or because some of the things like when Biden came in, he didn't roll back. He said he was going to, but he didn't because Congress wouldn't let him. What's the likelihood that this thing changes?
Well, first, there are 4 legal challenges right now to this rule. So 4 different lawsuits have already been filed. And all of the plaintiffs in all of those cases are seeking injunctions to prevent the Department of Labor from enforcing the rule. And they ultimately want a ruling that it's unlawful. We don't know the timing of those right now. On some of the other federal laws we're going to talk about, we have a little better idea of what could happen. So here we don't know. Now, if a new administration takes over, this is a regulation that went through the rulemaking process. So for them to change it, they're going to have to do just what the Biden administration did and tried to do an end run around and couldn't. They're going to have to go through the rulemaking process. So that will take some time. So they'll have to issue a proposed rule. They'll have to have a public comment period and then issue a final rule. So it's not as easy to change once it is a final rule that's in effect. Now, could Congress step in and pass some law? Yes, they could. But other than that, it would be the rulemaking process. Now, there's another case going on at the Supreme Court level that could affect this and every federal regulation we're going to talk about today. And a lot of people have heard about, it's really a pair of cases that are being heard by the Supreme Court right now, and they have the potential to affect the enforcement of a lot of regulations. And the cases address what is known as the Chevron doctrine. And that is a doctrine that's been used by courts for now some 40 years to defer to an agency's interpretation of an ambiguous statute. So under the Chevron doctrine, if there's a question, certain provisions have to be met and factors have to be in place. But it would basically give the court the authority to rely on the agency's interpretation of the statute. And if that goes away, and that's the big question right now, these pair of cases could actually eliminate the Chevron doctrine or modify it in some way, that all of a sudden the government agencies don't have nearly the authority that they had, and the courts don't have to rely on that authority. They can use their own independent judgment to determine what the statute means. They don't have to defer to the federal agency's interpretation. So those cases, and there's supposed to be a ruling on those cases by July, they could have a significant impact on all these new federal rules because it would open up the floodgates to litigation challenging the agency's interpretation of the statute. So, and that's a lot of what you hear today is you hear these cases coming out where the government is overreaching. It's overbroad. They're interpreting the authority that they don't have. Right. So the Chevron cases would have potentially an impact. That is not a legal analysis. Let me just say I'm not an attorney. That is just based on my reading of multiple articles about this. But it's got me excited because I deal with regulations every day of my life. And that is what we advise clients on. And we're always shocked when an agency will come out with a regulation that seems to be the exact opposite of what it was 4 years ago. Like you pointed out, Dan, when there's a new administration, all of a sudden everything changes. How can it be that you can interpret it one way and 4 years later you can interpret it another way? You can take away your own rule. And it just, employers are, it's like constantly changing and there's no certainty. It's difficult to plan.
It's hard to plan, yeah.
Right.
Yeah.
So I'm excited about that if it goes away. But of course, I'm not an attorney, so there's a lot of other implications associated with it that may not be so great. The courts are going to be over flooded, they think, if with cases, if this does happen. But it has potential to impact this role.
So on July 1st, we have the Department of Labor salary increase rule for exempt employees, aka the overtime rule, which that's one that affects pretty much all of our clients and people in the pest and lawn industry. So what's the gist of the new rule? How does that affect us?
So that this is, again, the Fair Labor Standards Act, federal law dealing with minimum wage and overtime. And a portion of that law is known as the white collar overtime exemptions. So the white collar overtime exemptions, there are 4 of them, but this final rule only addresses 3 of the 4, the executive, administrative, and professional. And that's why they're referred to as EAP, executive, administrative, professional. So this deals with the EAP overtime exemptions. And under those EAP, white collar overtime exemptions, 3 things have to occur. Okay, an employee must be paid on a salary basis. And there's a lot to that, guaranteed salary, when you can make deductions, that kind of thing. So salary basis. They have to receive a specified minimum salary level, and they have to meet certain duties tests. Well, the final rule deals with only one of those 3 things, and that is the minimum salary level. And so what's happening is the Department of Labor is increasing that. And this has happened numerous times in the past. And so, it's no surprise to most people. But this time it's a little different. This final rule is going to increase it in 2 phases, and it is adding a mechanism for automatically updating the salary level every 3 years. So it's broader in scope. And again, big question about, does the Department of Labor have the authority to implement automatic adjustments to this without going through the rulemaking process? And also just the amount. So what's bottom line for most employers, what they care about is, what does this mean in terms of the amount? Well, July 1, assuming this rule stays in place, the guaranteed salary level will increase from $35,568 annualized. And I'm using that word intentionally because the guaranteed salary level test is really a weekly salary amount. We all think of it on an annual basis, but you're not guaranteeing an employee an annual amount of money. Okay. Each week stands alone in the world of wages and hours. So it's really a weekly amount. And I like to focus on the weekly amount, but nobody else does. So now I'm using the annualized amount because that's what's in everybody's mind. Okay. So we're going from 35,568, which it is now, to 43,888. That's a 23% increase.
So essentially your CSRs now need to they get a $10,000 raise, or you got to pay them hourly plus overtime.
Well, let's make sure those CSRs first qualify for the exemption based on the duties tests that I mentioned, which are not changing. Mm-hmm. This is one of the issues. You have kind of an opportunity here. If you're looking at having to give somebody a $10,000 increase, maybe you need to ensure they are exempt, right? And if they're not, this is an opportunity to change that. And that's kind of what they're pushing. That's why it's called the overtime rule, and because people are going to end up getting overtime.
But if they were making the 35,000, we assume that they're exempt. So you can't say, well, listen, for 10,000 more, I want you to do X, Y, and Z, and that wasn't part of your job description. And the argument is, well, it's fine. My job description shouldn't change. I was exempt before, I'm exempt now. So where's the 10,000?
Well, and see, I would say that this is not the time to take that position. You should look at the duties and make sure they do qualify, because there is this opportunity where you could make a change and use this rule as the basis for that change. So it is something to look at. Now, January 1, if this rule stays in place, the rate goes up again to $58,656.
Wow.
So overall,
January of 25?
January 1 of 2025, right? That's a 65% increase over the current level.
Huge.
So it is big. And then there's going to be automatic increases starting July 1, 2027. So, and now there's something called a highly compensated employee exemption. That's part of the white collar exemptions. And essentially, nobody really pays much attention to this, but the rates increase there too. So, and this is different from, we think of highly compensated people for, ERISA rules and things. It's totally different from that. But if you have an employee who meets, well, first of all, they have to perform office or non-manual work. And then if they customarily and regularly perform at least one of the exempt duties or responsibilities of an EAP employee, and they earn, an annualized amount of what will be going up to $132,964 on July 1. And then $151,164 on January 1. If they meet that level, then they would be exempt. Right now, the HCE level, salary level, is $107,423.
Yeah, I thought it was significantly lower. Yeah.
Yeah.
Interesting. So you're probably maybe a general manager. You could use that, but your CSRs are going to go up to $68,000 if they meet the requirements, the administrative requirement, or you just pay them straight time and overtime. Is that right?
Yes, there are some other options depending on the state you're in. For example, the fluctuating work week is a pay plan that's a bona fide pay plan for non-exempt positions. It's not, I can't use it in every state, but it involves the payment of a guaranteed salary and then half time for every hour over 40 instead of time and a half. So that could be an option for somebody who's currently salaried, but maybe you don't want to take away the salary, but you need to pay the overtime.
Right.
I don't know. I mean, if I were sitting, I mean, not if I were, I am. It's all that hourly. Like I don't want to touch. I mean, the requirements of this is just so. I mean, they're so aggressive. It's just no way, right? Because ultimately, let's back up for a second. Let's just talk about reality. And what I mean by that is like we just can't artificially. I mean, the money has to come from somewhere, and there are market forces, and so it's not like you can just artificially say, "Well, this is what it's going to be now," and yeah, that's what I'm going to do, and that money comes from somewhere, and the reality of it is I just don't think in that position. Maybe in some markets, but at least the markets that I operate in, that is totally unrealistic.
Well, you got to go backwards to that straight time and overtime. But here's the problem with that. What if you have somebody who, is a great employee and they want to work overtime where, before they didn't really have to say anything? Or, Gene, how about if they work from home? If you give them a cell phone that they have to answer emergency calls or something, how does that work?
Yeah, they'd have to record their time in anything more than a de minimis amount of time, which we usually say is less than 7 minutes. They'd have to record.
Oh, lawyers charging 3-minute increments.
Yeah.
So I know that's work time, and that's another issue when you transition someone from a salary to an hourly rate, depending on where they work and what they do. There's again so many other implications that come into play, and also bonuses and commissions. Let's not forget that if somebody is hourly and they get a non-discretionary bonus or commission, that has to be factored in overtime. Mm-hmm. Yeah.
Okay.
Well, let's transition to what I think to be one of the oldest tools in our industry and one of the most controversial tools in our industry, which is non-compete.
And before you do it, I was going to say, and every M&A transaction that I'm involved in, it's a big issue.
Well, yeah, no, it's a big one. So let's talk about this change in non-compete because it's a big one.
Before we do that, I want to mention one quick thing, that there has been a letter sent to the Department of Labor about the overtime rule from a group of 88 business groups. And they are asking for more time to implement the first increase. And so there haven't been any lawsuits filed yet, but that is in the hands of the Department of Labor, 88 different business groups, some very large trade associations and groups. So there is a chance that there could be a little delay. So it's something to just keep a watch for.
Gotcha.
Okay. All right. Yeah.
Let's pull the snake out of the cage here.
Yeah, this one is really, this is a concerning one for many reasons. But this is the final rule on non-compete bans, and it's now going to take effect September 4th, barring any court ruling, of which, by the way, July 3rd, we understand that there will be a ruling from a judge in one of the lawsuits on this case, and she will rule on the merits of a motion to enjoin the rule on or before July 3rd. So I automatically skip to the end because I want to be in the end of the end of the story here, but because everything we talk about on this, it may go away. And of all these new federal laws, this is the one that we think has the most potential to survive a court challenge. So we will know something in another 6 weeks.
So by this going away, the non-solicit doesn't go away, right? So I can make somebody sign a non-solicit. You won't go after my employees or my customers, right?
So let's talk about that, because it does depend if it goes away or not. Because under the new final rule, all existing non-compete clauses cannot be enforced other than for senior executives. And I'll tell you the definition of that because it's very narrow. Okay. And then employers are banned from using any non-competes beginning again on September 4th. Covers all workers, independent contractors, employees, interns, volunteers, you name it, they're all covered. The federal FTC rule would preempt all state statutes and regulations, orders, anything, interpretations that provide less protection. And so it's very broad. And it also includes, to the point of use of non-solicitations, not just actual non-compete clauses, but functional non-compete clauses. So a confidentiality agreement, an NDA, a non-solicitation agreement that has the effect of preventing a worker from seeking or working for another person or starting their own business after they leave their job would also be prohibited. So they're going to look at these clauses and determine whether or not they function like non-compete. So it isn't that every solicitation agreement is okay. It may not be under the federal rule. Okay, so
we just need a couple of court cases with a few non-solicits that we know what it needs to look like. That's what we
Well,
need.
I get the non-compete, right? That's, sometimes those are a little, but the non-solicit, don't go after my customers, don't go after my employees. That's the key. And if that goes away, then it's going to be awfully difficult to do business.
Yeah. Yeah. I think they gave an example. I don't have it in front of me to be precise with it. But there was an example of if a customer was to solicit a former employee to work for them, that the employer would not have really any recourse, that they would consider that as an example where it should be permitted.
So we have in our engagement letter, we're not going after the employee, we're going after the customer. We actually give a price tag that says, this is how much you'll pay if you steal one of our employees.
Oh, okay. Mm-hmm.
And until September 4th.
No, but I'm not going after the employee. I'm going after the customer.
Going after the customer. Yeah. Okay.
Yeah.
Okay. So the non-senior or the senior executive, let's call it the senior executive sort of exception. And that would be a senior executive who has an existing non-compete. The employer could still retain that existing non-compete, but a senior executive under this rule is somebody who earns at least $151,164. And they're in a policy-making position. And they go into that and talk about the fact that that's like the president, the CEO, or some other officer of the business who can make broad policy-level decisions that affect the entire enterprise. So they have to be the final authority. They can't just make a recommendation. So somebody in charge of a department or a division would not necessarily meet this requirement. So it's very narrow. And even for that group, you can't enforce a new non-compete beginning on September 4th. So this is, I think this has potential to really impact the industry because the non-competes are used so frequently in the pest control industry. So it is something to be concerned about. And part of the rule, if it stays in effect, would require employers to notify employees who have an existing non-compete. They have to give written notification by September 4th that their non-compete will not be enforced against them. So it's there's that provision too. Now, Dan, you mentioned, M&As, and the use of non-competes in M&As. The rule does include an exception for people who enter into a non-compete that is pursuant to, they call it a bona fide sale of.
Right. So I can, the guy that I'm buying or selling
Yes.
but all of his employees, that's who I'm concerned about.
Right.
So,
Yeah. And that would be the problem. So, yeah, the buyer and the seller, that's really all you get from that. So, so it didn't take 24 hours, and 2 lawsuits were filed against this rule. I mean, they were already prepared, right? So, they were both in Texas federal courts. And like I said, last week, we learned that we will have a ruling on one of them by July 3rd. So for a lot of people, it's, fingers crossed that this won't go through. And I'll tell you, I mean, it no matter how you feel about non-competes, I've personally never been a fan of non-competes myself, but certainly understand why they're used. But the objective person looking at this would have to agree that it is just beyond the scope of what the FTC has ever done. To implement a regulation that prescribes how a business can compete in the marketplace at a nationwide level. They're not looking at individual non-competes to determine whether or not they restrict competition. They're just broadly saying that they all do. And they're basically nullifying tens of thousands of agreements that are in effect all over the country. And so it's just it really seems like an overreach. So I think we sit tight for 5 or 6 weeks and wait to see what this ruling is.
See what happens.
I think there needs to, I mean, at the end of the day, I personally, and this is my own opinion, I think it is too far reaching because listen, I'm all about protections, but there should be protections for businesses as well. And if you get into the area of non-solicitation, now there's nothing for the business, right? There's no protection for the business. And so there needs to be a balance, right? I've always said we used to use non-competes, and I would tell folks, I'm like, look, I don't care who you go work for. Just leave my customers alone and don't be taking the rest of our staff. And that's really all I want to do is just make it super clear up front. Like this is outside the boundaries. And if you do that, once you leave or our relationship's over, here's what's going to happen. And that was really the effect of it. It was not to like, your career is over.
Restrict them from working.
Yeah.
Right.
It never has been that. So I just feel like, I understand. I think maybe I don't know that I understand the intent. I can kind of see how the intent is. I just think it's probably overreaching and it needs to come back to the middle a little bit more. So there's protections on both sides. So
yeah, I wish it would. One thing to be certain, that the PMP should do is really make sure that they have a robust confidentiality agreement in place that protects some of the proprietary information, like maybe a customer list, right? Things like that. They're, talk with an attorney about how to do that and to protect your business to the greatest extent that you can.
Yeah. So let's wrap this. Obviously, those are the big 3. Are there any other new federal regs that you want to talk about before we finish out here that you feel like PMPs need to know about or at least be aware of?
Yeah, I'll mention 2 that also came online here the last month or 2. One is the Pregnant Workers Fairness Act. And this is a law that was kind of buried in the omnibus spending bill in December of 2022. Nobody knew it was there. We're all surprised when we heard about it. It's enforced by the Equal Employment Opportunity Commission. A lot of people are saying, well, what do we need a Pregnant Workers Act for, Fairness Act, when we already have protection for pregnant people? Under Title VII, you can't discriminate against somebody based on sex. That would include pregnancy. And don't they have something called the PDA, the Pregnancy Discrimination Act? And the answer is yes to both of those. But the new law expands not only the definition of pregnancy, but also the anti-discrimination protections. And they now include.
So wait. So they always said that, you can't be half pregnant. So it kind of seems like a black and white definition. How did that become a gray definition?
Oh, yeah. So pregnancy is no longer just being pregnant. Okay. Pregnancy. Pregnancy and childbirth now includes current pregnancy, past pregnancy, labor and childbirth, potential or intended pregnancy, which can include infertility, fertility treatments, the use of contraception. Okay.
Oh, wow.
And the law itself requires employers to make reasonable accommodations to qualified employees or applicants' known limitations related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions, absent an undue hardship. Here's the real problem with this. The related medical conditions, okay, in addition to expanding the definition of pregnancy and childbirth, the related medical conditions include this huge laundry list of conditions that are or may be related to pregnancy and that can occur years later, way down the road. So let me name a few, okay? Because even I, as someone who's had 2 children, did not know that there were a lot of these conditions could be related medical conditions. So carpal tunnel syndrome, chronic migraines, high blood pressure, anxiety and depression. Of course, we all see postpartum vision changes, changes in hormone levels, pelvic prolapses, fungal infections. I could go on and on. Okay. The list is very long. And the concern that employers have with it is, first of all, you're required now to have an interactive conversation. Now, I left off some of there are many things on that list that it's embarrassing to mention, but you're going to have an interactive conversation with an employee who has one of these conditions when they need a reasonable accommodation. So you're not getting out of that under this law. That's going to happen. Okay. And then in some cases you might say, well, wait a minute now, you're having an anxiety and depression, but you had a baby a couple of years ago. I'm trying to understand if this really is a related medical condition. So normally you say, well, let's get a doctor's note. There are restrictions on supporting documentation. So limited circumstances only, and you can only request certain things in the note. This is another one that has more tentacles.
So if this isn't a shakedown for money, what's a shakedown for? I mean,
well, hang on.
Forgive me for using the word.
I have fatigue. I have fatigue. Hang on, I got a headache, and I've got. Yeah. I mean, it's like any kind of disease or any kind of common. I mean, they all have similar symptoms, and so just the idea that you could pull that back to a pregnancy related event like that. But what are you trying to? I get it. If you have to provide, I don't know, pumping stations. But okay, so I have a migraine. Do you have to give me time off? Do you have to?
That's what we're talking about.
Okay.
So, and you can, under certain circumstances, again, you can get supporting documentation. So all a doctor would have to do is say it's related. It's a related medical condition. Okay. And if it is, then yes, you may be looking at leaves of absence, intermittent leaves. That is the biggest concern of all is the time off aspect of this. And how far out it could go. Now, again, a lot of these things would be covered under the ADA, the Americans with Disabilities Act, anxiety, depression. Those things are currently considered in most cases to be impairments under the ADA. Of course, it depends on the circumstances, but in a lot of cases they are. So a lot of these things would be covered under the ADA, which also is like, well, why do we need it here? If it's already a disability under the ADA that we would have to accommodate, now we're throwing this law into the mix. So it's going to take some time to see how it plays out. But of course, there was already a legal challenge less than 1 week after the final regulations came out. This is a lawsuit that was filed by 17 state attorneys general, and they're really questioning, and I didn't mention this, but the most controversial aspect of the law is the part pertaining to abortion and having to give time off for medical conditions related to abortion. And so they're basically, a lot of these attorneys generals are saying, look, it's not even legal in our state anymore. How can you impose a law on us that would require us to accommodate that condition? And so it could be that gets stricken from the final rule. They also said that the actual act itself that Congress passed in that omnibus spending bill, if anyone even read it, did not contemplate including abortion. And so they saying again, it's an overreach. So we'll see where that goes. So that's one. And then the other one that I think PMPs really need to know about are these new harassment guidance that was published on April 29th by the EEOC. So same government agency. And by the way, these laws pertain to employees with 15 or more employees.
So you can harass your employees if you have less than 15.
Yeah, well, you wouldn't be subject to Title VII. And so this, what this guidance does is it replaces 5 previous guidances that address harassment. It's the first time in 25 years that EEOC has issued a new guidance on harassment. And what the EEOC has done is they've incorporated new examples of what harassment is in today's new world. So whether it's a remote worker and harassment that can occur, online, to new definitions of sexual harassment based on sexual orientation and gender identity. And so what they've done is they have taken the Supreme Court ruling from 2020. It was a case called Bostock versus Clayton County. And in that ruling, the Supreme Court held that the Title VII definition of sex includes gay and transgender employees. And some people may say, well, what's the big news there? I mean, isn't that how it was always interpreted? But that particular case involved a termination of an employee. And the allegation was I was terminated because of sex, because I was gay, because I was transgender. So what the EEOC has done is taken that ruling and applied it to the harassment guidelines, but they have gone beyond the ruling to include gender identity. And where that becomes a challenge for some employers is that they have stated very clearly that employees have the right to use the bathroom or sex segregated facilities of their choice based on their gender identity. So they consider denying an employee access to a bathroom or other sex segregated facility that corresponds with their gender identity to be a form of sex-based harassment. They've also stated in the new guidance that repeated and intentional misgendering of a person or outing a person, those are forms of harassment based on sex. So that could change a lot of policies in a lot of workplaces. And so, as you might imagine, again, there's a legal challenge to this. And it was last week that this lawsuit was filed by attorneys general in 18 different states, and they're trying to block the enforcement of the guidance based on their concern about the bathroom and preferred pronouns. And essentially what they're saying is, the Supreme Court made it clear that you can't terminate an employee based on their sexual orientation or being a transgendered person, but there was no accommodation ruling. That ruling didn't include accommodating people based on gender identity. And what EEOC is attempting to do is require employers to accommodate employees based on gender identity. So that's kind of the gist of that lawsuit. It is a guidance. It's not a regulation, but it functions like a regulation. It is in effect right now. It was in effect immediately when it was published because it was a guidance. So could affect policies, sexual harassment policies and practices, of course.
Yeah. I guess like most things, it's what's the enforcement look like and what's that going to, I mean, obviously I don't want to be the one that's the poster child for it, but at the same time, like sometimes my head just starts swimming and like we're always going to be out of compliance for something, you know what I mean? Like I don't know. It's interesting. We certainly need to have you back when some of these court cases are settled. And the problem is like, but we may have a new a new administration. So it'll be changed again.
That's what's going to happen, right?
So it's like, wow. But anyway, so I would just say we probably need to bring you back in the fall. And I would love to hear just kind of an update on these 4 specific things, because I mean, all of them, it sounds like all of them have some sort of challenge associated with it in the court system. And that's going to have big impacts on enforcement and what the final ruling looks like. So Dan, anything to add? Any other questions before we finish out here? This has been great, by the way, Gene. Always a pleasure to have you.
Will you be posting your bathroom policy on the show notes or no?
I am not. Certainly not.
Just
You know what? It's funny. Well, I'm not going to go down that road. Sometimes politics and regulation and what people feel like it's a hill worth down on just baffles my mind. I will just say that. Don't understand it sometimes. But all righty. Well, Jean, this has been amazing. It's always great to have you on board. It's always great to have you out. And I know that our listeners very much appreciate having you on the show as well, just to get us up to date on what's going on and what's happening. Just a reminder that all the resources and topics that we talked about today are available on the podcast website. We'll link up Jean's website as well. You just go to pmpindustryinsider.com, take a look under show notes. And Marisa will do a great write-up of this. Good luck, Marisa, because that was a lot of information. And as always, if you enjoyed the show, please review us and rate us. We appreciate all of that. And if you have any complaints, concerns, or just general, I'd say general complaining at all, please pass that on to Dan. And with that, we'll all see you next time. Take care. Bye-bye.
Thanks, guys.
See ya.
Take care. Bye-bye.
Yeah.